Hello and welcome to Passing the Bar, a video lecture series brought to you by Delaware Law School. My name is Professor Brett Bendistis, and today I want to provide an introduction for a assignment that we have through the Canvas page. Now, if you're a Delaware Law School student, you should be accessing this video either through Canvas or through email, and this corresponds with one of our sample MEE questions that we're providing for all of our students. Now, the sample MEE question is a 2015 civil procedure question. It deals with three very discrete procedural issues, and that's part of what we're doing here today. Part of it is dealing with civil procedure, obviously difficult issue. We're going to talk about what to go over later. It's kind of part one of a two-part series. But the big thing that this lecture is supposed to be intended to cover, because this is shortly after graduation, congratulations, by the way, testing the idea of how do you mix the idea of lectures and writing? What are we supposed to get out of the lectures? How are we supposed to work through them? I want to tell a very short anecdote really quickly, and I'm going to talk about the point of this video. When I took the bar in 2007 and 2008, the way that we did it is we would go to campus and then we would have class for 3 to 4 hours where it would be either a video lecture or it would be a live lecturer who would just talk for the entire period of time. While that was not in the convenience of my own home, right? I like to work super late at night or super early in the morning, and I sort of had to correspond with the class times. But the good part was it was a set schedule. I had no choice, right? Had to be there. If I wanted to get the material, I either had to go at one of the two sessions, I had to sit there the entire time. I couldn't pause it, I couldn't change it, I couldn't catch up, right? That was the time, that was how you had to do it, and that's what worked for me. The part that I wouldn't say I'm concerned about, right? But the part that I think is different, and I think that would be hard to navigate, is the idea, how do you self-motivate yourself to watch all of the lecture videos on your own time? Bring this up also because I was having a conversation with someone in the hallways of the law school, sort of someone who had worked with mentors and mentees in the past, and she had mentioned that one of the biggest problems that she saw was that students would often take too long with lectures, meaning that the lecture was 4 hours, students would spread it out over like 2 to 3 days, right? Or they would have a 2 hour lecture, it would take them 8 hours to do it. And the problem is that you fall behind, right? These programs give you a schedule, and they give you a schedule for a reason. You have to hit every single mark. And so I think a lot of the times perfection is a fantastic goal, but the idea that you can memorize every single video during the video when you take it, I think is somewhat unrealistic. And I think it's a difficult expectation to have for yourself. And so one of the things that we're going to do here is that we're going to provide a civil procedure question for you and a video lecture. That's it. It's just a video lecture. There's a PowerPoint. And here's the challenge that you have. And think about the challenge and the point of why we're doing this. I want you to just watch the next video. It's Professor Zhang, who's a fantastic professor here at Delaware Law School, and she's just going to talk about the focus material that is relevant for this question. I want you to watch the video once and take notes, right? It's about 20 to 30 minutes. Challenge yourself to see whether you can just watch the video one time and then do your best to answer the question. Send that material to your mentor and see what the feedback is. Now, the good news about this is that, one, it gives you a good self-assessment of what the expectations are, meaning that, how perfect do you have to be? How much detail do you need? How serious do you have to take the videos in order to get them together? Because again, the point is, if there's a schedule, you have to stick with the schedule, and you can't really miss anything. You can't catch up on other days. I think often what happens is that students fall behind and they just can't catch up. And so that's sort of what I'm trying to challenge. That's sort of the main focus here, to remember this. This assignment is not about perfection. This assignment is about testing yourself, a skill you probably never had before, and that you maybe won't ever have to do ever again after the bar. I mean, this is a somewhat unrealistic preparation that isn't sort of mirroring practical legal work. Practical legal work doesn't require you to memorize the same level of material, but that's sort of where the bar exam is. And so, key thing, see the idea of how you can get through the assignment, see what your comfort level is, and sort of use this as a very small example to set you up for the bar exam in the future. I will say one last thing before I go. Congratulations on graduating law school. I always said that my law school graduation was the only graduation I've ever really enjoyed. In that it was just it felt like something that was a real accomplishment, and it's something that you should be really proud of. This is obviously the next big step, but if you've gotten this far, the bar exam is well within your reach. It takes a little bit of time and a little bit of work, but enjoy yourself, enjoy your family and friends and the accomplishment that you had. I'm going to pass this over to the video lecture. What I'm also going to do is that later in next week or two, I'm going to post a answer video for this to sort of like a part two to go over some of the questions and to think a little bit about how do we look at lectures? How do we think about memorization? How do we think about what level of detail we need here? So good luck with everything. Again, complete the lecture, complete the assignment, send it to your mentor, and good luck.
All right, hello everyone. I'm Professor Zhang, and I'm here to teach you a few topics about civil procedure that will help you as you get ready for the bar exam. So today's topics are federal subject matter jurisdiction, service of process, and third-party complaints. So not anywhere close to all that you need to know for civil procedure for the bar, but just a few to get you started and to be able to do some problems. So, just to give you a sense of where we're headed, under the rubric of federal subject matter jurisdiction, I'll touch on three topics today: federal question jurisdiction, diversity jurisdiction, which will include a discussion of what counts as corporate citizenship, what states are corporations citizens of, and then supplemental jurisdiction. Then we'll move on to service of process, which is how you bring a defendant into the case. So we'll talk about doing that for both individuals and corporations, and then we'll talk about how sometimes there are difficulties when there's a conflict between a state law service of process rule and a federal one. So that brings in what you might have learned about the Erie Doctrine. And then finally, we'll fall back on what's constitutionally required as a minimum. And then very quickly at the end, we'll talk about third-party complaints, which are a very niche Civ Pro topic that I want to make sure you know what they are so you're able to work with that topic. So without further ado, let's get into federal subject matter jurisdiction. Um, to kind of zoom out and make sure you know what subject matter jurisdiction means, I often tell my students this is one of three what I call technicalities that a plaintiff needs to make sure they satisfy in order to file their case in the right court. So the other two are personal jurisdiction and venue, but subject matter jurisdiction goes to the kind of case that we're talking about. Is this kind of case allowed in this court? And since we're doing federal subject matter jurisdiction, we're thinking, can this kind of case be filed in federal court? So that jurisdiction is limited by the Constitution, which breaks it down into three categories that are allowed in federal civil court. First is what we call federal question cases, cases arising under federal law or involving the U.S. or foreign states as parties. We think of that generally as federal question jurisdiction. A second category we call diversity jurisdiction. And under the Constitution, what you need is some kind of diversity between the citizenships of the parties to gain that diversity jurisdiction. So there are two categories. There's one that we don't usually talk about much in civil procedure, but that's admiralty or maritime jurisdiction, stuff that arises on the open waters, on the sea. That's also allowed in federal court. So we're just mostly going to focus on number one and number two here. Federal question jurisdiction is relatively easy. Federal district courts have federal question jurisdiction over civil actions arising under the Constitution, federal law, or federal treaties. So that's fairly simple. If you see some kind of federal law mentioned in the case that gives rise to the claim, then you have federal question jurisdiction. And that case is allowed to be in federal court. The second category, diversity jurisdiction, is a bit more tricky. So two main requirements here. First, you need to have what we call the amount in controversy, what the parties are fighting about. Usually it's the amount that the plaintiff wants in damages, might even be a piece of property. But that amount in controversy has to be greater than $75,000, and that's set by statute. It's not equal to $75,000, it has to be more than $75,000. So that's a requirement if you're bringing a case under what's called diversity jurisdiction. The second requirement is that requirement to have some kind of diverse parties. So this is pretty technical. I kind of break it down for my students as having either citizens of different states, so state A and state B on either side of the V, or you need citizens of a U.S. state and citizens or subjects of a foreign state. So someone from a foreign country who's a citizen of a foreign country can sue someone else from the U.S. in federal court under diversity jurisdiction. Or you need a foreign state, like another country, as a plaintiff and citizens of a U.S. state. So that's what you need to satisfy for diversity under diversity jurisdiction. There's a little bit more there in terms of complete diversity that you should know, but I'm not going to get into today, just out of the interest of time. What can get dicey, though, is that citizenship kind of makes sense if you have a human being. We know what it means to be a citizen of a country and even a citizen of a state if you're a citizen of the country and you live in that state. But what about corporations? They're not human beings. What counts for their citizenship? So the law gives us an answer. Under statute, a corporation has two potential citizenships. They are a citizen of the state where they are incorporated, and that could be either a US state or a foreign state, and they are a citizen of the state, again, either US state or a foreign state, where they have their principal place of business. Um, but what does that mean? What does principal place of business mean? We have a case called Hertz Corporation that gave us the answer to that. A principal place of business is going to be the place where the corporation's officers, their CEO, their CFO, those are the officers, where they direct, control, coordinate the corporation's activities. It's often called the nerve center, and usually that'll be the corporate headquarters. Not always, but we're looking for that place where you have the CEO making those decisions, and that's going to be their principal place of business. Even if a lot of their business happens in other states, we're looking for that corporate headquarters, and that's going to be where their principal place of business citizenship lies. So that's what's going on there. Our third category of subject matter jurisdiction I want to get to today is something called supplemental jurisdiction. The first two categories, federal question and diversity, are those that are most important. There's this third category, though, that hooks on to those other two. It basically hitches a ride into federal court if there's a claim that can make it into federal court under federal question or diversity jurisdiction. So the rule here is that if you have a case where there is federal question or diversity jurisdiction, you can get supplemental jurisdiction over other claims in the case that on their own couldn't get into federal court. And the key there is to figure out, do those extra claims, those supplemental claims, form part of the same case or controversy as the federal question or diversity claims. To give us a little bit more detail of what that means, the courts look to, do those extra claims, those supplemental claims, share some kind of common nucleus of operative fact? Do the extra claims turn on the same evidence and witnesses that the federal question or the diversity claims turn on? If so, you're looking at a situation where probably we're looking at the same case or controversy, and we might be able to get those claims into federal court. So there's a lot more to learn there when it comes to all those kinds of jurisdictions. But that's just a quick and dirty overview of some of those three main ways you could get a case into federal court. Our next topic is going to be, once you're in federal court or even state court, a plaintiff hopefully has satisfied all those technicalities to make sure they're in the court that has jurisdiction and that is the right venue. Then we need to bring in the other party, usually the defendant, because they don't automatically get notified that they're being sued in court. That process happens through this thing called service. And that's really important, because if you're a defendant and you don't know you've been sued, you won't know what's going to happen in court, and you won't necessarily know that stuff might happen that might implicate your interests. So courts take service pretty seriously, and most of the time it happens without a hitch, but it's important for you as lawyers to know what are the rules there, because if they're violated, that can really create a problem for any plaintiff filing their case. So let's get into that. There is a rule for individuals, and then there's a rule for corporations. So I'm going to tell you both. And again, our topic here is mostly federal court. That's typically what's tested on the bar exam, so that's where we're starting. But we'll get a little bit more into state law too, as you'll come to see. So if we're trying to get someone notified that they were sued in federal court, the rules give us, federal civil rules of procedure, give us a particular set of ways a plaintiff can notify the defendant if the defendant is an individual. So there's 4 ways. First, you can do it simply by following whatever the state rule is for service in the state where the district court sits. We have federal district courts all over the country. They're in all different states. And so the idea is, if under state law you could serve someone in a particular way, then the federal court in that area should be able to follow those same laws too. So that's one way to serve someone to get them into federal court. Another way explicitly authorized by the federal rules is just to serve to deliver the summons and the complaint to the individual personally. So the complaint is the document that sets forth the plaintiff's claim against the defendant. The summons is this extra document that tells the defendant, you've been sued in court and here's what you need to do to respond. Both those things need to get sent to the defendant. So if you do that personally, meaning you show up, find the person, and give them those documents, that's called personal service, and that's appropriate under our federal service requirements too. Another way under the federal rules is simply to go to the individual's address and leave the summons and the complaint with someone of suitable age and discretion. So basically serving them at their residence. And you don't need to find the exact person, but if you leave it with a person that seems trustworthy, then that can satisfy our federal service rule as well. Finally, one last option given under the federal rules is to deliver the summons and complaint to an agent that maybe the person has designated. If they tell you, I'm going to let this person receive my summons and my complaint, then you could deliver it to that person too. That's fairly rare. So that's what's required under federal law. You need to satisfy one of these four options if you're serving an individual. Now, again, we have the wrinkle. That makes sense if the person is a real person, but what about corporations? They're kind of these multi people entities. Not all of those categories make the most sense when you're serving a corporation. So, luckily, we have a specific rule about serving corporations. If you have a federal case and you're trying to bring the corporation is in as a defendant, this is arguably an even simpler rule. Again, you need to deliver the summons and the complaint, but there's just two options here. Under the federal rules, you can follow the state law that's applicable in the court in the state where the district court sits. So often states have their own particular rules for serving corporations. Um, that aside, though, there's also the federal possibility that you could simply deliver the summons and the complaint to a corporation's officer, meaning one of their board of directors or maybe their chief executive officer or to their managing or general agent. So one of those high-level employees, if you deliver the summons or the complaint to one of those people, then that satisfies service of a corporation under our federal rules. So those are your options for serving someone to get the defendant into federal court. But one thing to keep in mind, although those federal rules allow you to serve someone under state law, they provide these extra federal options, leaving it at someone's place of residence. So sometimes that can raise the issue, what if there's a particular kind of service that the federal rules allow, but actually if you're looking at the state where the federal court sits, they don't actually allow that kind of service. And that can implicate choice of law issues, trying to figure out should the state law override the federal law, or does the federal law on the other side, on the other hand, preempt the state law? This is where your Erie Doctrine comes in. The Erie Doctrine is generally that if we're thinking about substantive law, meaning what are the rules of decision to figure out whether the defendant is liable or not, for substantive law, we generally are going to apply state law, except for situations where there's some kind of federal question, right? If it's a case involving breach of contract, tort law, lots of things that aren't implicating federal law, in general, even in federal court, we apply state law, and that's the Erie Doctrine. But when we're thinking here about service of process, we're not really in substantive law territory. And luckily, there's a very clear answer on this. Sometimes you'll get Erie questions, and it's unclear whether you're in substantive law territory or procedural law territory. Luckily, for service of process, the answer is clear because we have a Supreme Court case specifically on point. You may have read it for your Civ Pro class. It's called Hannah v. Plumer. And the Supreme Court said there that Rule 4, which is the federal civil rule governing service of process, Rule 4 is definitely a procedural rule. And the rule for the Erie Doctrine rule, when you have a procedural issue, is that to the extent you're in federal court, the federal procedural rule is going to govern, except for very specific exceptions, namely if there's some kind of constitutional issue with the federal rule, or it's invalid as a federal rule, or if it just doesn't quite answer the question that the state law does. And that can get pretty dicey and pretty tricky. But what we know under the Hannah case is that when we're talking about service of process, that is very definitively a procedural issue. And so you can fall back on the federal rule, even if there's some kind of state law rule that conflicts. So in the Hannah case, someone was served at their place of residence, which was permissible under federal law, under our federal civil rule, but wouldn't have been allowed under the state law, which was Massachusetts. Um, so, what you need to know is that when you're doing a service of process analysis, even if you see a fact saying that a state law has a conflicting rule, the federal rule will be the governing one in federal court, and that's the one that's going to supersede the state law rule. So, you don't need to worry about the potential problem that the state law conflicts with the federal one. You just go with the federal rule. All right. One last point on service of process. We've been talking about federal court service of process and kind of specific requirements about how you get it done. In the background, though, as with so many things in the law, in the background, though, is the Constitution's requirement that the laws be administered with what's called due process of law. And there are certain procedural guarantees. Um, and so in civil procedure, we think about the idea that under the Constitution, a defendant should know about what's going on if it's going to implicate their property in court. And so due process requires that they be given notice and an opportunity for a hearing appropriate to the nature of the case. And that notice has to be reasonably calculated to let the defendants know about the case. So why am I telling you this? I'm telling you this because sometimes, even if a state law's service of process rule or a federal service of process rule has been 100% complied with, there are still situations where, for whatever reason, the defendant doesn't actually get notified about the case. And then stuff happens and they lose their property or they lose some kind of interest. And they might feel like this is totally unfair and unjust, and they might really have an argument under the due process clause. To give you an example, you might recall the Moulin case if you read it in law school. Um, in that case, the state law allowed people to be notified of a case against them by newspaper. And this was back in the day where maybe more people read the newspaper. But nonetheless, the Supreme Court said that wasn't going to be enough to really make sure defendants knew about the case. And they rooted that analysis in the Constitution. That wasn't enough due process of law. Likewise, there was a case where a state law allowed someone to be served by U.S. certified mail, which is typically a very good way to notify someone. It has tracking. You can make sure that the letter was delivered. But in that case, the letter was never claimed. And so even though they technically served it by certified mail, or at least attempted to, the defendant was never actually notified of what was happening in court. And the Supreme Court again said that wasn't due process of law. So if you see facts where the defendants aren't getting notice of the case, even if state law or federal law has been complied with, and your gut is telling you that can't be right, then you should listen to your gut, because probably there's a constitutional problem there, and maybe there wasn't notice that was reasonably calculated to let the defendants know about what's happening in court. And even if the federal rule or the state law rules of service have been complied with, a court might still invalidate whatever happened in the case under this idea that it violated due process. So that's one last point to keep in mind for service of process. Our final topic is third-party complaints, a very niche topic. You may have covered it when you learned about all the different kinds of pleadings that one can bring in federal court. Typically, we think about the complaint and the answer, but there's all these other things that you can do. You could bring a counterclaim where the defendant sues the plaintiff. You could do a cross-claim where multiple defendants might sue each other. And then there's this thing called a third-party complaint, where a defendant will bring in a third party to the case as a new defendant, often saying that, plaintiff sued me, but actually it's this other party that's to be blamed. And so they bring in a third party defendant by filing what's called a third party complaint. So that's interesting. And one thing to keep in mind, if you ever see a third party complaint in a problem, is that you can't do this third party complaint against everyone in under any situation. There are limits because otherwise cases could get very large and sprawling. The civil rules make it pretty limited, the situations where you can bring in a third party defendant. So a defendant is allowed to assert a third party complaint against a third party defendant, as I mentioned earlier, but here's the limit. That is only if the third party can be held liable or is alleged to be liable to the defendant for all or part of the plaintiff's claim against that original defendant. So to put this another way, if plaintiff is suing defendant about certain injuries, say it's arising out of a particular car crash, the defendant has to be able to link up any third party complaint to that initial car crash claim. Maybe they're going to bring in their insurance company because that insurance company is going to be on the hook for any claims defendant pays out to the plaintiff. Or maybe they're going to bring in the other car that was involved in the crash because maybe that car is actually to be blamed for what happened to the plaintiff. Those are both permissible situations because they're all linked up to the same car crash. However, if our car crash defendant has some kind of beef with their neighbor, some nuisance claim, and they want to bring that claim into the same federal case, even if that might satisfy jurisdictional requirements, maybe it's a diversity jurisdiction case, or maybe it's a federal question case under some kind of federalized nuisance law, that doesn't matter because this rule limits the idea that you can only do this third party complaint mechanism if it's actually related to the original claim against that first defendant. So if you see a third party complaint situation, you want to make sure that they're really still talking about the same claim that the plaintiff was bringing against the defendant in the first place. And that's it in terms of our topics for today. Happy studying and good luck.